So Sandie Peggie was a nurse at Victoria Hospital in Kirkcaldy. She'd worked there for some 30 years, and she had complained several times in the autumn of 2023 about a transgender doctor, Dr. Beth Upton, being allowed to use the female changing rooms at the hospital. Now, Dr. Upton is a biological male but identifies as female. But then on Christmas Eve that year, the two of them got into some kind of altercation, a row, when they were both there attempting to use the changing rooms at the same time. And afterwards, Dr. Upton accused Ms. Peggie of bullying and harassment. She made a formal complaint against her. But then Dr. Peggie decided to take her employers, NHS 5, as well as Dr. Upton, to the employment tribunal. And that is what the ruling is that we've had today, this 312-page judgment. And was based on a number of hearings that were held earlier this year in February and July. They called more than 20 witnesses. They had more than 3,000 pages of evidence to pour through. So it clearly was complicated.
Hi guys, welcome back to the channel. So an important case concluded recently, the Sandie Peggie case. Well, it's still going to be appealed, but as of now, a judgment has been passed down, and many are calling it a partial win because Sandie Peggie did win in certain aspects of the case. But ultimately, the most important factors that we want acknowledged, that men cannot enter into women-only spaces, weren't really acknowledged. And, you know, people aren't happy with the overall judgment.
On behalf of Sandie Peggie, I should like to say the following. I am beyond relieved and delighted that the tribunal has found that my employer, Fife Health Board, has harassed me on 4 separate counts after I complained about having to share a female-only changing room with a male colleague. The last 2 years have been agonising for me and my family. I will have much more to say in the coming days once I've been able to properly consider the lengthy judgment and discuss it with my legal team. For now, I'm looking forward to spending a quiet few days with my family. I'm so grateful to my incredible legal team, Naomi Cunningham, Lead Counsel, Dr. Charlotte Elves, Junior Counsel, and Ms. Solicitor Margaret Gribben. There are many others I would like to thank, and I will do so in the coming days. And the following is an interim statement on behalf of the legal team. The tribunal's findings that Fife Health Board harassed Sandie Peggie is a huge win for a tenacious and courageous woman standing up for her sex-based rights. This has been an extraordinarily lengthy and complex legal case. After hearing evidence for over a month from some 21 witnesses and considering just under 3,000 pages of productions, the tribunal today delivered a 318-page judgment. Due to the length of the judgment and the fact that the legal team only received it this morning at 10 a.m, we will not be in a position to make substantive comments on it today, although safe to say that our preliminary thoughts are that aspects of the judgment are hugely problematic for women, leaving the onus on them to object when their privacy, dignity and safety are violated when men are given access to single-sex spaces.
So a legal expert has said that the Employment Tribunal did make up new rules on trans women's access to female-only spaces that were incompatible with a landmark Supreme Court judgment. Dr. Michael Foran, an Oxford University professor who specialises in gender law, noted that April's Supreme Court ruling found that single-sex services should be based on biological sex. However, he said that Monday's tribunal ruling had created other criteria, such as a trans woman's hairstyle, clothing, and what surgery they had had. He said employment judge Alexander Kemp had created a new test that was not compatible with the thrust of the Supreme Court ruling. He said that Mr. Kemp had also appeared to formulate a second new test, that it was lawful for a trans woman to enter a female-only area if no one complained. So basically, people are saying that it leaves the onus on the woman to complain rather than to provide a female-only space as an employer to begin with. The onus should be on the employer to provide a female-only space for all women and to exclude men. But instead, it's saying, according to this tribunal, based on the judgment, it's saying that, if no one's bothered by it, let the man who identifies as a woman enter into that space. But if the woman complains, then the employer has to support the woman. And, it basically concluded that Sandie Peggie wasn't supported by her employer and that they failed her in many aspects. But there are still a lot of holes that need to be addressed. And then recently, it's also been revealed that there was a line in the judgment that wasn't even present in the case that was cited. That line never existed, and it's been attributed to AI. The legal expert went on to say that Miss Peggie would have strong grounds for a successful appeal. But of course, when it comes to the appeal, it means she's going to have to spend more time and more money following this through. The tribunal ruled that the health board had harassed Miss Peggie, but dismissed her allegations of discrimination, indirect discrimination and victimisation. It also rejected her claims against Dr. Upton, who was named as a respondent in the case. Mr. Kemp found that it was lawful for Dr. Upton, the man, to use the female changing room at Victoria Hospital in Kirkcaldy, Fife, before Miss Peggie complained, and after they were put on separate shifts. He said that the trans medic's feminine clothes, hairstyle, and pronouns should have been taken into account before deciding which facilities should be made available. His ruling also said there was very far from sufficient reliable evidence to show that biologically male trans people posed a greater risk to women in female changing rooms, which just isn't true. Men pose a risk to women in female changing rooms, and them having a gender identity doesn't negate that risk. If anything, on the contrary, if a guy has a fetish, makes him even more of a risk, if you ask me.
And what they ultimately concluded is that they've partially upheld her claim of harassment, but they have dismissed a number of her other claims, particularly about discrimination and victimisation, and all of her claims that were directly against Dr. Upton. But critically, they've upheld the claim of harassment in the sense that they say NHS 5 should have taken action when she initially complained about Dr. Upton's interim right to use the changing rooms, and they say that should have been suspended until the work rotas were changed so that the two of them would never be attempting to use the changing rooms at the same time. They also, as you said earlier, said that it took far too long to investigate her case. But the broader question, as you say, has huge ramifications, because it really is a case that became so high profile because it gets to the heart of the really fraught rows that have been waged for so many years about the conflicting rights between trans rights and women's rights, particularly a big issue here in Scotland. Now, the tribunal itself didn't say that it was wrong that Dr. Upton should have been allowed to use that female changing room, but that the hospital should have acted differently when Sandie Peggie complained about it. As you heard her lawyer there highlighting earlier, that's not something that has gone down very well with her legal team and gender critical campaigners who say it puts the onus on a woman to complain about this situation, which seems rather to go against the spirit of the Supreme Court ruling earlier this year, which found that that sex was a matter of biology under the Equalities Act. But clearly we're still waiting for the government to issue their guidance onto how public bodies should be interpreting that law.
So it's already been concluded that she more than likely will win the appeal. But of course, she still has to go through it to ensure that the judgment is based on acknowledging that men, no matter how they identify or how they dress or how they look, do not belong in female-only spaces, especially at a place of work. And it's up to the employer to provide and protect those female-only spaces, not to wait for the woman to complain after she's encountered a man in her changing room. Sal Grover said, "I have a theory. The judges know this, but the process is the punishment. So, for stepping out of line as a non-compliant woman, they punished her with having to do an appeal she will inevitably win. It remains an example to all women. Step out of line and we will waste your time. So the mysterious line in the judgment that was supposed to be on the previous case, Sandie Peggie's tribunal judgment, was revised after an allegation that a vital quote was made up using artificial intelligence. So Judge Kemp cited the Equality Act, which the Supreme Court ruling acknowledged is based on biology. However, Judge Kemp said there was nothing stated specifically in the Act itself to say the protected characteristics of being a woman takes precedence over that of being a trans person, which I find very ironic because this whole movement, where men want to go into women's spaces, is actually creating a precedence of giving men who identify as trans special privileges, extra rights, while diminishing the rights of women. That's what the outcome of this whole movement is, and that's what's being addressed, by the Supreme Court ruling. So he quoted the Maya Forstater case, the chief executive of sex-based rights charity Sex Matters, as concluding that it is important to bear in mind that the Equality Act 2010 does not create a hierarchy of protected characteristics. However, Ms. Forstater said the quote was made up and did not appear in her tribunal. She suggested that it had been produced using AI. She said one of the many things wrong with the Sandie Peggie judgment. This quote from the judgment doesn't come from my judgment. It is completely made up. Sal Grover said, once one accepts the lie that a man can be a woman, they'll continue to lie to uphold the original lie. J.K. Rowling also commented on this discrepancy as well. She said, Judge Sandie Kemp and the Judicial Office need to explain exactly how this bogus quote made its way into the ruling. Misrepresentations of the Forstater ruling are commonplace in the trans activist community. But for this to turn up in an actual court ruling is truly shocking. Ms. Forstater argued that the source needs to be investigated and they need to ask Judge Kemp where it came from. It's very easy to explain. Where did you get that quote from? So she said that he may have had a team of clerks working on the report, and whether the judge or one of his administrators used AI should be investigated. We deserve an explanation, and that might be one, she added. There are several errors in the judgment beyond the made-up quote attributed to my judgment. Mistakes like this severely undermine people's confidence in the legal process. Or maybe he has some trans activists working for him who decided to, slide that quote in there. Who knows? This judgment was already being questioned because it seems to fly in the face of the Supreme Court's clear statement that single-sex facilities can only be on the basis of sex, not claimed identity. Errors like this just add to the growing feeling that this is not a sound judgment. The new version of the ruling was issued just after 2 p.m. on Thursday. The quote attributed to the Forstater tribunal case has been changed to, this judgment does not mean that those with gender-critical beliefs can misgender trans persons with impunity. The claimant, like everyone else, will continue to be subject to the prohibitions on sex discrimination and harassment under the Equality Act. Whether or not conduct in a given situation does amount to harassment or discrimination within the meaning of the Equality Act will be for a tribunal to determine in a given case. The Peggie ruling then added, we consider that quotation provides support for the proposition that the Equality Act 2010 does not create a hierarchy of protected characteristics. Okay, if that's how you want to interpret it. However, there was no explanation as to how the original quote was sourced. Of course not. Asked for an explanation, a Judicial Office spokeswoman said that judges speak through their judgments and no comment would be provided on individual cases.
I am not a campaigner and had never heard of the phrase gender critical when I first raised complaints over 2 years ago about my employer's decision to allow men into female-only changing rooms. I just knew instinctively that it wasn't right that women were expected to undress in front of men in private spaces, and I still believe this to be the case. Whilst I am delighted that the tribunal was critical of Fife Health Board and found they had harassed me, their judgment, I believe, falls short in many respects, and that is why I certainly won't be giving up this legal fight anytime soon, and Margaret will tell you more about that. Finally, I want to pay tribute to my late dad, who we lost in January, and who I know will be looking down on me feeling proud that he, with my mum, raised a daughter who did not and will not wish.
Wow. So Sandie has announced there that she intends to appeal. She's not going to let this slide. And, you know, these courts need to be held accountable. The Supreme Court ruling is very clear. It didn't establish, you know, a new law. The Supreme Court ruling simply clarified, and if anything, proved that these, you know, tribunals and these employers, they haven't been following the law. They haven't been following the law. They've allowed a piece of paper held by a man that says he's a woman to determine that that man has a right to enter into women's spaces. And Supreme Court said that was wrong this whole time. So, you know, so happy to hear that Sandie Peggie, she's not going to let this go. She's going to appeal. The appeal is more than likely to be successful, but she shouldn't have to. She shouldn't have to do any of this. Women shouldn't have to spend, you know, thousands upon thousands of pounds fighting this, fighting and trying to convince their employers that men can never be women, no matter how they dress, no matter how they identify. And we're never going to be comfortable with men in our spaces. Never. Even if there's one or two women who claim to be okay with it, they don't represent the majority. Single-sex spaces exist for a reason. This whole time, single-sex spaces should have been protected, and it was a huge mistake not to protect these spaces based on identity. So let me know what you think. Thanks for watching. A like, comment, and subscribe. Take care of yourselves, and God willing, I will see you in the next video.